You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument.
Welcome. Our guest today is Richmond, Virginia trial lawyer Sharif Gray. Sharif, welcome to Best Practices.
Thank you. I appreciate it, Kenny. Now I'm glad we're connecting. And it's been great following you and becoming a friend over the last couple of years. So thanks for having me on.
Yeah, man. I remember our first conversation, I think, is when you were first starting out on your own, or maybe you were getting ready to go out on your own. And I remember at the end of the phone call, it's like, man, this guy's going to do great. He really doesn't have anything to worry about. I just kind of want to be like, dude, you have nothing to worry about. Just trust me, you've got it. You're going to do great. Enjoy the ride.
Well, I appreciate it. Well, I've been very lucky. I work with Gray Broughton, who started this firm a handful of years ago, and I teamed up with him a little over a year or so ago. And we've had some great results since then, and it's been a lot of fun. And then the ironic part is his first name is my last name, so we confuse a lot of people in the process. But it's been good. We do only personal injury. The unique thing about our firm is that all of the lawyers, there's three of us, we're all former military. So I'm Army JAG, Gray's Army, and then our other lawyer is a former Marine. And actually, our senior paralegal is a police officer. So we've got the whole public service thing going pretty strong, which is fun.
Fantastic. Thank you for serving. So with your practice, tell us kind of how Sharif Gray came to be a trial lawyer.
Sure. So I guess bottom line up front, an accident in many respects. I had no clue what personal injury was or what really what civil practice was when I was leaving law school. In my mind, I was a prosecutor and that's all I wanted to be and all I wanted to do. I loved the movies. I loved A Few Good Men, hence the whole going into the JAG Corps thing. And I love the idea of like getting justice, right? Having accountability, having this noble purpose. And so for the first, I'm gonna say 5 years, I was in the Army JAG Corps. I then went and clerked for a couple federal judges. And then I tried my hand at big law, one of those massive big corporate firms. Did not enjoy it. Good people, good money, good resources, but the work was boring and really just kind of didn't fill my cup when it came to having a sense of purpose. So I moved on, went right back into criminal work and was a prosecutor, eventually did some defense work, and then found personal injury. And I've been doing that now 4 or 5 years, I think, and have come to truly love it. So largely because one, I get to do the trial part of it, and two, it's still got that, at least in my view, this work still has that noble purpose in that we're not only, if you're handling cases the right way, pursuing the deterrent factor, right? Like trying to make the world a safer place. But on top of that, you're asking juries to recognize the full and fair value of human life, of what was taken from your client's health, quality of life. And to me, uh, I find a lot of purpose in that, and it's something where I get to wake up every day and really, really enjoy the work and the people that I get to help. And even better than criminal law, at least I get to give our victims, our clients, a check, hopefully at the end of the case, versus just sending someone to jail. So I've fallen in love with the practice. I've fallen in love with the bar. I've been fortunate enough to travel around the country to go to a bunch of these conferences. Everyone is so gracious and collegial and helpful, and it's nothing but constant learning. And I couldn't see myself doing anything differently. So very excited to be in this line of work.
I love it, man. And the passion comes through. Sharif, what are some of the transferable skills or similarities that you've seen between criminal prosecution and really what equates to civil prosecution?
Yeah, so they're very similar. And actually, a good friend of mine, Niall Bazaki, gosh, he spent 12, 13 years. He just took the bench, but he spent 12, 13 years as a prosecutor. And I kept trying to convince him, like, listen, man, it's the same job, just you're dealing with money and you're not dealing with jail sentences. And he's on the bench now as of like a month ago. So congrats to him. But hopefully one day I can get him to come over here. But It's you're building, so from the plaintiff side, just like in the prosecution side, you are building a case. So you're the one who puts on the case. So in terms of kind of practical skill sets, it's the same. Lots of direct examinations, making sure you've checked your elements. And another huge thing is by coming over from the criminal side, your criminal attorneys get a lot more trial experience. They're a lot more familiar when it comes to or used to getting motions practice done in a meaningful way that I found, and I don't think I appreciated it when I was doing my criminal work, but I found that my experience has let me come into the civil world and then learn a little bit of civil law and immediately become effective, or at least think I'm effective, perceived to be effective, in the sense that I have no problem going into a courtroom and trying cases. And a lot of the skills that I learned trying cases as both a prosecutor and a criminal defense lawyer have helped me significantly because I do believe trying a case is trying a case, regardless of what type of practice area it is. There, there are certain there's it's a certain skill set, and it requires a certain level of experience, I think, too, to do it right. And you can be the most well-versed lawyer in a certain practice area, but not have the requisite skill set in a courtroom, and you're going to struggle. Whereas I think if you were to flip the roles, um, a good trial lawyer may not be able to handle themselves in the litigation aspect of the discovery aspect of maybe that specific practice area, but throw them in the courtroom, chances are they're a quick learner and they'll be able to tell the story. And I think that's why we see people like the Nick Rowleys, the Keith Mitnicks of the world, they're able to jump in and just try the case so often.
Yeah, and I love that idea. I mean, to me, it's you talking about a few good men. It would be a lot easier to teach Tom Cruise a few things about civil prosecution than it would to teach a, you know, prosecutor a whole lot about acting. It's just
Right.
it's two totally different worlds. And when I look around at the plaintiffs bar, some of my favorite plaintiffs attorneys and some of the most successful plaintiffs lawyers I know have that criminal prosecution background. So for anyone who is a current criminal prosecutor thinking about making a move, you've got a resource in Sharif and someone who's done it and done it well. So you had mentioned direct earlier, and we're going to be talking a lot about direct and redirect in today's episode. So when it comes to direct examination, what are some of the key principles, big picture ideas that you like to apply or prepare for when you're getting ready to or conducting a direct examination?
So there's a handful of things. And it took me, I think, a while to come to actually enjoy direct examination. For the longest time, I thought it was kind of just a necessary evil. Not evil, but like just one of those tasks you kind of just get through. Now, the approach that I've adopted, I've come to enjoy it. And I think the reason why is because it's not as hard as I think a lot of us make it out to be. You don't need these massive outlines. You don't need this perfect rehearsal with the client or with the witness. You just really have to remember that we're not here because of us. We're here to basically help facilitate the telling of the story from the witness to the jury. I pulled up my kind of outline I use for direct to make sure I didn't forget some of the things that I often think about and use when I'm doing a direct examination. But to start with, I think it's really helpful to understand that we're not the star in direct examination. We want the witness to be having a conversation in some respects with the jury. Granted, the jury can't speak back. And so we want whatever we do, we want to facilitate how we're doing direct examination in a way to accomplish that goal. So let's see, how do I start? Let's start with kind of just some of the kind of the content piece. So it's very common that you walk into a courtroom and you see a lawyer call someone on direct and they say, "All right, what's your name? Spell it out for the record, da 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 da." We can take that snippet and already kind of dissect what's wrong and what could be done better with that. When you call a witness to the stand, the lawyer stands up and says, "Your Honor, plaintiff calls Bob Jones to the stand." The bailiff or the sheriff, whoever it is, goes, "All right, Bob Jones," runs out to the hallway. "Bob Jones, come on over here," right? Bob Jones takes the stand. puts a hand on the Bible, raises the right hand, swears, tell the truth, all that. By the time that witness is seated, everyone in the courtroom knows who Bob Jones is, right? And so, why in the world do we as lawyers need to waste the very first part of our examination, the part where everyone's paying attention to what's your name? Bob Jones, right? So, what I like to do, and I think I learned this really from Joe Freed, is ask myself, well, what do they need to know? Like, what does the jury need to understand right now? It's not his name. They already know what that is. And frankly, his name is not that important. That's not why they're here. He's here. The story that he has to share with us, and I say us, not the jury, because one thing you want that I've tried to incorporate is we're building a tribe. So it's not tell the jury, it's share with us because we're all part of the same group trying to get accomplish the same mission, which is justice for the client. And so a good way to start with a witness is instead of the name or the title is, hey, can you share with us what your role is in this case? Right? Or why you are important in this case, or why do you matter, right? However those words come out of your mouth, it's fine. But the why that person is there is an incredible way, I think, to start. And then we like organization. So instead of uh, diving into just an outline, let's lay it all out for the jury right at the start. So, for example, what's your role? How can you help us understand X, Y, and Z? Yes, I can. Can you also help us understand this and that? I can. Well, what makes you the right person to help us understand that? Well, I was there. I saw what happened. Or, well, I went to Harvard, Yale, da 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 da. I've been doing this work for a million years. Great. All right. Well, now that we have a good idea about what your role in this case, let's go ahead and talk about that first thing we mentioned a second ago. Let's dig into da 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 da. So we kind of, I mean, by starting by not burying the lead, by getting right up front at the beginning with what the purpose of this testimony is about, and then giving the jury a kind of an outline of what you're going to go through in somewhat of a conversational way, in a way that makes sense, is something that I try to do, and it's something that I think really sets you up for success when it comes to direct examination. And what I've learned after doing this a number of times is it's easy because you're not wedded in this outline where you have to hit every single wicket. You've got your chapters. Like I was just in Texas a few weeks ago for a case against Ford, and our direct examinations, I mean, it'd be one page, and I would have, I mean, for a damages witness, for example, I would have 4 or 5 bullets, and that's literally it. Because if you have prepared your case the right way, and you've spoken with your witnesses, you've spoken with the client, you understand what you're trying to achieve, then you already know what you need to ask. You already know what the jury needs to get to go your way. And so now it's just your job to get out of the way and let the witness speak with the jury. And that applies to both your lay witnesses as well as your expert witnesses. There really isn't that much of a difference. Because if we put ourselves in the jury's shoes, right? They're looking at a human being sitting on the witness stand telling them information, right? They don't really expert non whatever like that, all that fancy legal stuff. That's for us to bicker and think there's some importance to it. They just want to know, what do these people have to share, and and should I trust what they're saying? Why should I listen to them? And anyways, but before I get too far ahead, that's how I typically recommend setting up the direct examination. But if we want to, it probably, Kenny, it probably makes sense to go back and understand like the planning that goes into a direct examination. Would that be helpful, or should we?
Yeah, please.
Okay, so when we're talking about planning a
Because
direct
you actually,
examination,
it's funny. It's
yeah,
one of the questions I was going to have was, hey, when you're looking at your various witnesses that you're calling that make up the different parts of your case and how these different witnesses and their testimony works together, what is your general approach in terms of first building the case to understand what you're going to be trying to solicit or elicit during direct examination? So you have said it more concisely than I just tried to explain it when it really didn't need explanation. So yes, run with it on the planning.
let's do it. So let's talk about, yeah, just planning. So everything in life is an argument. I remember a long time ago when that light bulb clicked. I was like, wait, so a resume as an argument? I'm like, well, how is that? Well, the way what you choose to put in, what you choose to keep out, how you choose to organize things, the order, it's all for it all is somewhat of an argument. And so that means who we choose to call as a witness, who we choose not to call as a witness, and what order we put them in are are all decisions that need to be made with the point that you're trying to advocate in mind. So it depends is typically the answer on any given case, but the frame for a personal injury case, the framework that I like to follow is that my client, one, isn't in the courtroom, and then two, when they testify, if they testify, I typically do have them testify, they're at the very end. Because the last thing you want, in my opinion, is a client doing the advocating for themselves, right? You want everyone else to explain what happened and how they've been impacted, and then you kind of just introduce your client quickly at the end. You don't want your client to be doing the heavy lifting. So that so in now in terms of like damages, liability, oftentimes as lawyers, I think we can get stuck in this mode of, well, I need to prove liability and then I need to get to damages. And in some respects, sometimes that's kind of what we expect of ourselves, and that's our default. You don't have to do that. Um, I do think it often makes sense to lead with liability, not necessarily because that's what the jury has to decide first, but because I'm a big believer, like many of us, that good liability can drive damages, and frankly, sometimes it's more important than damages. So I do like to lead off with witnesses on liability that have little room for impeachment. And Kenny, you and I actually spoke with this a while back, but I do believe in what Rowley teaches is you want those first few witnesses after your opening statement to give you credit, to give you credibility. In that one, they are telling the jury exactly what you told the jury they'd see and hear. And then two, there's not much the defense can do with them. So now you've done a good job in voir dire, developing rapport, getting rid of the jurors that don't need to be there, and framing some issues, right? Opening, you've prosecuted your case, you've told them exactly what they're to expect and why your side should prevail. And then your first few witnesses are reinforcing everything you just said. And in our world, getting to go first, I mean, that's you could be potentially done with day one, and I don't want to say you've won the case, but you are way ahead, right? Before you get into anything that's more controversial. So that's kind of typically my approach in terms of organization. Now, in terms of preparation of witnesses, that's a whole
Well,
different world.
Sharif, just
Yeah.
to jump in, a suggestion, practice tip, whatever you want to call it, that I got a couple years ago that resonated with me, was when possible, and if it makes sense, right? Kind of preface with, if it makes sense. If that first witness can show that the defense's opening is bullshit, or the first two or three witnesses can all show that, like, not only are you right, but they're wrong, and now open the floodgates, and really start building, then it's a beautiful place to be. And I'm with you. I mean, and something I'm doing a workshop on soon out at TOU in California. And heck, by the time this is aired, it'll probably have already been done. But you know, tying the bad conduct to those big damages, and like you said, not just being like, we've proven this element, and now we're going to go to this, and now we're going to go to this, and now we're going to go to this, which may have a very nice linear, logical progression, but it could be really boring and not very persuasive versus, kind of figuring out the different ways that, hey, like you said, if I'm putting together a resume, yeah, if I follow a traditional resume route, someone may look and say, this is very conventional. This is sound, and it also looks like every other resume that I've seen today, versus something that's maybe a little less conventional, but is far more persuasive. So I love you adding the caveat of kind of what are we doing that is an argument that's most persuasive, and the classic it depends, but also saying, all right, let me start where I'm strong to build my case, beat down theirs, and for God's sake, not make every single point that I'm arguing where my client is the centerpiece of it, or where their credibility or their prior health conditions or fill in the blank, whatever the defense wants the case to be about. Now all of a sudden it's my case in chief.
And let me piggyback off that. I'm a firm believer that for us to be successful in a courtroom, the case isn't about our client. The case is about the defense, which I know sounds crazy, right? Like, what do you mean? Personal injury case? Like, you're asking for money for injuries and all that? Yes, of course. But the reason why I don't have the client in the courtroom, and I know many people have a number of different reasons, but for me, the biggest thing is I want to look like a prosecutor. The reason why we're here is not because of us, not because we're unreasonable and didn't take what otherwise would be considered a reasonable settlement offer. The reason why we're here in this courtroom is because the other side is the unreasonable party. And if that, for me, that is always the theme. Like, we have a trial in 4 weeks, and it's soft tissue, car crash. What we're doing now is thinking about what are our angles. And hopefully this episode is not out. Well, I can't even imagine they're going to listen to it within the next 4 weeks or so. But I can tell you,
You're
hired
good.
a hired a defense medical expert, never saw the client, and just read a record review and came out with the arbitrary line in the sand: 6 to 8 weeks. Anything past that, no go. Instead of accepting responsibility, they do that. They're going to claim the guy that we're representing as a chiropractor himself. They're going to claim his inside baseball knowledge is fraudulent and that he is trying to work the system. So we're going to get ahead of that and use that as a, hey, why are we here? Because they're accusing him of being a fraud. And so we're looking and we're trying to come up with what are the things that we can really dig in on that encourage the jury to think, wait, these guys aren't here because they're the greedy plaintiffs attorneys you see on the billboards, right? They're here because the other side committed a wrong, hasn't accepted full responsibility, and is trying to dodge some level of accountability.
And
So,
I think for both judges and juries, they're always trying to figure out like who's the problem. Like anytime I've
right.
ever been, and I kind of learned this first in the setting of motions hearing. So it's when it first kind of dawned on me that if the judge thought that I was the problem, we would get ruled against. If the judge realized the other side was the problem, the ruling would go more in our favor. So it's like I think it's just kind of human nature. And if I get down in the mud with them and wrestle around, they think both of us are the problem. Um, so I can demonstrate through words and action, like I am not the problem here. I mean, it ain't me. And I can signal those things without having to having to browbeat it. And people are smart. You put 6, 8, 10, 12 people together, their collective intelligence and IQ, is gonna be far greater, and in life experience it's gonna be much more than any single person's. And they tend to pick up on it more frequently than they miss it.
Yeah, absolutely. And the cool thing about us is we get to go first, just like a prosecutor in a criminal case. So we get to frame everything. And we get to, like, let's say, because the defense, oftentimes, I've found, Kenny, and I'm sure you've probably experienced the same, they're never going to come out and say your client's lying. They're never going to come out and say the witness is lying, right? But I think it's our job to expose their, what's the right word? What they are actually trying to do. And so by going first, we can, in some sense, already paint the defense's position for them, which is a massive benefit, right? So in a case where I'm representing a felon in a personal injury case, one of the things that I'm always going to do is, one reason we're here, it's because the defense doesn't want to give full justice to our client because he's a felon. They don't care that he rehabilitated himself. They don't care that he's now a functioning and a contributing member of society. He's got felon tied to his name, and that's one reason why we're here. Because the defense is never going to say that, right? They'll insinuate it, but they'll never say that. But that's a huge opportunity to frame a case, and then by going first, like, gosh, we have.
Well, and, I mean, a couple things that dawned on me just kind of when we've had, you know, folks who've got a criminal history, especially a felony. Um, well, heck, I mean, you can't argue out one side of your mouth that, this person deserved their sentence and did their sentence and that was fair. And out the other side of your mouth, that when this person caused them harm, they get to pay any less than 100%. What's fair is fair. Also, we've had somebody, it's like, look, there was no part of their sentence, right? The thing where they went to prison and did probation or whatever, paid their fine. there wasn't anything in their sentencing that also said, and by the way, 10 years from now, we're going to have a tractor trailer run into the back of you, and they're going to hurt you so bad you're going to have to get your body opened up and have hardware placed inside there, and limit your ability to work and do things with your grandchildren. That was not part of it, right? It just ain't part of it. So if they bring it up, if anyone brings it up, you know, it it didn't have anything to do with getting hit from behind by a reckless truck driver or whatever kind of the it is.
I
Um,
love that. That's something I'm gonna have to use.
I
So
mean,
no,
check
that's
it
great.
out. It depends on the audience, right? Because if you got, and it also depends on the venue. If you're in a venue, because there's some venues in South Carolina, probably similar to Virginia, man, the people on that jury are going to relate more to the person who's being punished for something they did 25 or 30 years ago, or has a family member who they can relate to, than they are the person who's arguing that they should be judged 30 years later for something they did as a teenager. Um,
Absolutely. And it's, I mean, and that's especially in your admitted liability cases without huge injuries, um, finding those angles, those leverage points, I think are critical. And so, how does that relate to direct? Well, get like in the you're representing a felon. Well, now we get to have testimony about the guy's rehabilitation efforts. Now that he is a small business owner. He employs people, right? You get to tell this kind of resilient story, which is so important because we want our clients to come across as, well, not just to come across, but to be, and oftentimes they are, people who've dealt with hardship. And instead of sitting there, woe is me, I mean, they're climbing out of that hole. And despite the fact that they were hurt at no fault of their own. So all of this stuff, it's weird, but the trial is not as segmented as I think I once thought it was. It all kind of gels together, and there's a fluidness that I think comes from experience, and but probably more important than that, just understanding like why you're there and like what are you trying to do. And because you can, in every part of trial, you can, and I'm not doing a good job explaining this, but you can help advance that goal versus kind of which come leads to like the sometimes I find it's hard to like split up trials. I mean, I don't do trials on my own anymore. But I think it's important, like for voir dire and open. Oftentimes, I think it's important to have the same person because now you've developed a relationship with the jury at that point, or at least attempted to, and now you get to tell them about what this case is about, right? So, anyways, but trials are fluid and a function. And actually, now let's get into a little bit of preparation, which I think this ties nicely into that, is because we prepare like crazy, right? Like, um, and it's never going to work out as we expect. Like you get into trial, things will change. A witness will be sick. You're gonna have to rearrange now your witness schedule. Or there's a ruling that comes in last minute that's like, oh, yikes, I can't say that anymore. I've got to adjust. But I've always thought that, well, at least if you really, and I'm kind of, and I'm sound like a broken record, but if you truly understand like what you're trying to do and how you're trying to get there, like you understand the why, you as corny as it sounds, you can find the way to get there, regardless of what phase of trial you're in.
Yeah, I've
But
got a buddy who always talks
yeah,
about, man, there's more than one way to skin the cat. You can't get it in there. I was talking to a young lawyer buddy of mine. He was getting ready to try a case, and he was trying to figure out exceptions for the law enforcement officer to be able to talk about how the wreck happened. And here, like, you can't introduce the collision report. Law enforcement officer, is limited to what they can testify to as a regular old witness, right? They can't attribute fault, like unless they saw the wreck, they can't talk about how the wreck happened. They can just talk about what they saw, did, heard, so forth once they arrive. And he was trying to figure out kind of these ways around it. And it was like, well, let's back up a little bit. What is it you're trying to show? He was like that the defendant isn't credible. I was like, okay, let's look at other ways we can show the defendant lacks credibility versus, trying to kind of put this elephant of law enforcement testimony through the eye of a needle. Um, and you could tell on the phone he had this aha moment, like, oh yeah, yeah, okay, well we could do this, we could do this, we could do this, we could do this. And, we can contrast like what the other witnesses saw with what this person told the law enforcement officer. And here are the ways it's not hearsay and the hearsay exceptions. And it's like, you got it,
Yeah,
go have fun. Um, but to your point, you get a bad ruling. And I love this point that got made. I can't remember who it was a while back, but it was, hey, the more restrictive the judge is, the harder the judge or otherwise is making it on us or on the other side or both of us, the more we can figure out creative, agile means to still prove our case where the defense is boxed in, where they've got that straitjacket because they haven't run it past 4 layers of insurance bureaucracy ahead of them or above them. And it gives us a chance to shine. And if it didn't work out that time, well, learn a lesson, apply it to the next one, and write it off to practice.
that's right. Now I mean, the creativity of this work is I think one of the best parts of it. But yeah, and especially when it comes to trial work. I mean, and direct examination. I mean, I've gotten people off the stand to demonstrate things, use visuals to have them teach things, right? I mean, there's so much you can do. And I think a lot of us uh, sometimes like, well, are you sure you're allowed to do that? And my response is just do it. I mean, you do it with confidence. Chances are it's going to be just fine. And chances are, if it helps the jury understand the testimony better, then it's perfectly permissible with often rare exceptions. So the creativity I think that goes into it is super huge, and if whatever we can do to help kind of convey that message to the jury in a more effective way, the better. And so that kind of leads, I think, to preparation and storytelling. So a few years ago when I first started personal injury, I laugh at myself now when I thought about how I was going to approach a certain witness. But I was like, all right, in Virginia, we've got the different damages elements, pain, suffering, inconvenience, medical bills, all that. And my thought was, well, let's just have the witness kind of go through each category and share examples of each category. And very formulaic, right? And um, I did it in that case. The case also ended in a mistrial, but I just remember the testimony just not being terribly effective. And it wasn't a mistrial for that reason, but for another reason. But was, it wasn't story based. And what I'm starting to learn more and more is like, I don't need a recitation of every aspect of a person's life and how much they're and how they're injured. I just need each witness, especially a damages witness. I just need a couple good stories. That's it. So when we're preparing clients or witnesses to testify, my preparation, well, let's separate witness versus a client's testimony. If they're just a witness who they have some important information to add, I'm telling them one, of course, to tell the truth, right? That's like the only thing that anyone can ever ask of you. And then I'm asking for stories, and I want to know, like, what did you see, right? And often an example I can use is I'll get a witness and say, well, I knew he was in pain. Okay. Uh, well, what do you mean by pain? Um, and he's like, well, he was just really hurting. And I was like, all right, well, I understand I mean, I'm a personal injury lawyer. I hear about pain, really hurting all the time. But what I want to know is, did you ever see something where it's like, hey, he had trouble getting up the steps that he'd never had before, right? Or if he can't go out and do this thing with his kid that he used to always do every Sunday or something like that. We want stories to be able to share the impact something has had on the client. Or we want stories to tell the liability story, right? And so when I'm preparing witnesses, just trying to find those stories. Granted, if there are certain things that I need to check off elements, obviously I'll bring those in. I'm also certainly in my head trying to think about what are the potential defenses and get in front of those. Or if there's bad facts, right, that aren't necessarily great for that witness, and certainly you want to get ahead of it. You don't want to wait till it's brought up on cross-examination. Now, in terms of clients, uh, there's in a perfect world, I would love to be able to afford, and I wish every case could justify bringing in someone like an Andrew Capel-Shaw or one of these psychodramatists, or just someone who can really, really spend some time and professionally help the client prepare to be a witness, because it's just not an easy task to do as the client, right? Testifying about your case. And it's certainly not necessarily an easy thing for the lawyer to prepare it, because us lawyers, we have our own kind of lawyer minds, and it's a little bit different, I think, when you're actually trying to prepare the client to testify. Now, the one thing that I've used with a lot of success is there's a lady named Elizabeth Larrick. She is a trial consultant out of Austin, Texas, and she worked with the Reptile, the Keenan Edge group, and developed a witness prep course. I don't think I'm allowed to talk about the details of it because they make you sign a confidentiality thing when you take those courses, but it's incredible. It just does a really good job empowering and preparing the client or any witness for that matter to tell their version of the truth, their story. And I highly recommend looking into that for those who want to get better at witness prep. It's a ton of work. It takes a whole day for the first part, and then there's a mock cross on the second day and another mock cross on the third. But I've seen it do absolute wonders. But gosh, there's so much to tackle when it comes to witness prep, and ultimately the answer for anything is it depends. But if we're thinking about what do we want to do, what do we need to do to get our message across, that pretty much dictates everything that we choose to do. And one thing that can be very helpful, which I learned through the Jerry Spence course, at the ranch is this idea of present tense. This idea of, and I found it helps witnesses as well, of don't tell me us what happened. Tell us what is happening right now. So, and a good way to set that up I've found is I could spend an hour telling the witness in advance. I want you to do present tense. I want you to close your eyes and pretend you're there and explain the five senses, what you see, what you smell, all that stuff, right? It never works because the witness gets nervous, the client gets nervous on the stand, and they immediately resort to one, looking at you instead of the jury. So what do you do there? You turn your side and you say, share with us. And so now the witness has no choice but to look at the jury and not you. And then the next thing you do to really kind of get that present tense is you use transition phrases and you can use them quite liberally. And I've never gotten an objection, at least not that I can remember, or at least not a successful one that stopped me from doing this. But you can, in that transition phrase, you can look at the witness and you can say, all right, Bob Jones. And then you turn to the jury and you say, I want to take you back to September 21 of 2022. You're in your car, you're driving home. What do you see? Right. And you're still looking at the jury. You're not looking at the witness. And so the witness is now, you've guided them to where they are, and they're like, oh, what do you see? Well, I see the road in front of me. What else? Right? I see this. Tell me more. Um, is that what else do you see? All right, what do you hear? What do you feel? I mean, all those things to really help us get in that person's shoes can be incredibly effective. And then the cool thing is, Kenny, it's like it's just not hard. Like it seems daunting, it seems hard, and I've found, and I was this used to do this myself, but when lawyers struggle is when we have this urge of wanting to lead, or do kind of the in between open and leading question of the did you this, did you that, right? And it's a lot. All we have to do is listen to the story, use appropriate transition phrases when need to, and then simple questions like tell me more. Why? Well, how's this? What else? Those are the types of facilitators, the types of questions that really kind of, I think, help paint a vivid story. So, anyways, I can ramble on, but it's really not difficult, but it takes time, I think, and practice to have the confidence to just do it and to get away from the notepad and to get away from the million questions that you prepared in advance and just say, all right, this is what we need to share and do it. And it's really helpful to the witness because then you can sit there when they're nervous beforehand and you're like, hey man, I know you're nervous, but guess what? Here's my notes for you. It's 4 lines. I'm going to ask you about this, and that, right? These 4 things. That's it. And you're off to the races.
Excellent. Well done. Sharif, let's talk a little bit about redirect.
Sure.
What
So
are,
go ahead,
go ahead.
please. So redirect is I used to years ago, I can't believe I'm saying years, I'm 35, so I'm not that old. But I do have 2 kids, so that puts some time on me, I guess. But redirect needs to be used with the mindset of the jury is not dumb. I found early on that anytime a point was made, I felt the need to combat that point. So if a point's made on cross and I just felt this urge, I have to get up on redirect and address it. I no longer take that approach uh, because the jury gets it, right? Like if you've already, if it's a trivial point that doesn't need to be addressed, then don't get up and address it. Or if it's a point where like you should have owned and you didn't, well, you're going to look like an idiot trying to cover it up in some respects on redirect. And so it depends. I mean, I can give you a good example of where I thought redirect was appropriate and effective. I was in Texas a few weeks ago trying a case against Ford, and my client was on the stand and he had taken oxycodone for many, many years for back pain. This was a carbon monoxide poisoning case, product defect case, and and a brain injury case. And on cross, Ford kept trying to give the impression that our client was testing positive for fentanyl at a management clinic that he was a part of, where he got his narcotics for his back pain. And they kept bringing up things like, well, you had a positive test for this, and that. And our client wasn't too terribly open in kind of rebutting that, which was fine. Like they don't need to be. That's why we have lawyers, right? We get to get up and help kind of close the loop if need be. So the defense attorney, in some respects, was giving the impression to everyone in the courtroom that he's had a handful like false positives for some pretty serious drugs. What the defense attorney chose not to do was to explain that those false positives were in fact false positives, and that the clinic he was a part of suspected no opioid abuse, and that there was documentation to that fact, and that the clinic is not one where if you are found having used illicit drugs, that you can remain a part of the program. So redirect there was appropriate because I got to get up and say, can you share with us what the point of that program was? Sure, it's to get better. It's to use to help facilitate these pain management medications and da 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 da. Did they let people use illicit drugs, right, when you're a part of the program? No. Why? Why else, right? And so redirect there was able to kind of crush the defense attorney's attempt, or at least I thought it was, at trying to paint the the client as this drug abuser. And so there I thought it was an appropriate use. But it just redirect is something that's very much a judgment call. I do not plan redirect in advance because I mean it's based off of in large respect off of the cross-examination. Now, if it's a very long cross-examination, there are times where even if there isn't necessarily a point that I need to rebut, there's something that I want to remind the jury of, like the central point or the two or three main points. And so you can get up on redirect, and I think it's proper then not to rehash everything, but just to ask a couple of questions that refocuses everybody to actually kind of where we started. Why did that witness show up in the first place, right? Like what was their role on direct? Why does their testimony matter? Um, I do see problems with redirect when we go too far. And when we try and rehash the direct, or when we want to take every point on cross, and we also have to remember some judges allow an additional cross or sur cross, right? And so if we don't want them to have that opportunity, we need to be really mindful of whether or not we're going to pursue redirect. And one other thing before I be quiet, and have to remind myself of this often, and I think this is probably good advice for most of us lawyers because we all are type A and we want to win at everything, right? Is you can lose a battle but still win the war. And that applies to witnesses and trial work. You can have a witness that doesn't crush it for your case. That's just mediocre, right? And that's okay because your case is that or your case is not reliant solely on that one witness. Your case is a combination of things, and you're framing the all the evidence in the case, everything. And so it's okay if that one witness may not have been as strong as you'd like, and it's okay to just stop.
Well said. You know, on redirect, I think a lot of times it may come down to putting one or two, maybe at most three things kind of back in context. You know,
Right.
I'll give you an example. We had a doctor treater who was being cross-examined, and they were trying to make it sound like this doctor was a flip-flopper. He thought one thing and later on, changed his mind. And when he changed his mind, it just so happened to be more in line with what the plaintiffs wanted. Well, all that was true, but it wasn't the reason for it. I mean, the reason for it is, you know, doctors, you've received more information about a patient. What is it that you do as a medical doctor? Hey, doctor, let me ask you, you've got doctors yourself? Yeah. If you went to a doctor who didn't take additional information into consideration before you needed, say, a surgery, is that someone you'd ever want operating on you? Absolutely not. And what are the reasons for that? Oh, well, we learned in medical school, and so doctor, if you and others in your profession quit taking additional information into account as you treated patients, would any of us be safe? Absolutely not. What did you do here? I took additional information into account. Thank you. You
Yeah,
know,
that's great.
but it's just kind of like it's that question of what's really going on. And I think I can't remember if it was Joe Fried or someone else who I first heard say that. But when you take a step back and you look at it big picture wise and say, like, what's really going on here? For me, kind of a guiding thought in redirect is like, what's really going on? Are they calling my person a liar, a cheat, a fraud, a malingerer? Are they claiming that this witness is biased, that the expert's just doing it for money? Whatever that it is, if it needs to be addressed, great. And like you said, sometimes it's just like, when asked the question, any redirect? No, Your Honor. May the witness be excused. That's it.
Yeah, and then sometimes that's a great move because it can show that you're confident in the direct, you got what you needed, and that the cross didn't do anything.
It depends. It
That's
depends.
right. No, of course, that's the answer. But yeah, I like your point, Kenny. It makes a lot of sense. You're like exposing the lie, right? Like or it's like the family member when the
Without getting up there and being like, doctor, would you do, and it's like when a defense person gets up there, someone says like, you wouldn't come into this courtroom and lie, would you? It's like, well, sounds like they did.
yeah,
I was just
yeah, yeah.
talking
No,
about this
it's
with I can't
I've
remember if
seen
it
that a
was Dan
handful.
Ambrose or somebody else, but it's just I think it's another way of just kind of again putting things in context, calling attention to what's really going on, exposing the other side's motives, and like showing the why your witness did what they did or said what they said is appropriate and really kind of best practice versus some weird legal game that the defense wants them to play that like is totally at odds with how human beings behave. The only person in here making decisions based on the legal process is it may be one person in this courtroom, but it's not my client. You know what I mean?
Right, right. No, it's I don't know. The tricks are many, but it's our thing. It's our job to kind of expose them and to, as you said, put things back into context, right? Like,
And yeah, in defending a case, like, the more I think about most cases, if you handed me a defense file right now and I needed to go defend that case tomorrow morning, okay. I mean, here are the 4 or 5 defense playbook things. In my mind, it's much easier to defend, a straightforward personal injury case than it is to prosecute one.
absolutely.
And the amount of and you did a great job talking about the amount of preparation, the time that not only you're spending, but that you're spending with your client, additional witnesses to fortify your case, to not only build but truly fortify your case against these efforts to poke holes or tear it down. So well done.
Well, thank you. No, it's a lot of fun, and you can get really creative with direct examination and I mean every part of trial I find now is fun. So it's good stuff, and it's just not the big thing I want to convey to people is like it's just not that hard. And I don't say that from like a oh look at me. Like no, like just stop giving yourself like unrealistic expectations or you need to do this or you need to go in this certain order. You need to have the perfect question because you just don't. You just don't. You just need to make sure that you're helping facilitate the story from the witness to the jury. And sometimes that just means asking, tell me more or why. Like that's it. I think it takes a lot of weight off the attorney, um, and puts it right where it needs to be. The focus, at least, is on that story. So,
Man,
anyways,
you're doing a great job. For folks who want to get in touch with you, are you barred just in Virginia, or are you barred other places?
barred in Virginia, DC, Pennsylvania, and then of course we'll pro hoc in every once in a while. So it was just in Texas. That case is actually still going. There is an issue after trial that has warranted a new trial or a motion for a new trial. So which we're still tackling. North Carolina potentially, but yeah, so it's fun stuff, but mainly Virginia. We handle cases all throughout Virginia. We're based out of Richmond, which is an awesome town. It doesn't look great when you're driving through it on 95, but if you take an exit off of 95, it's a cool place. Tons of
Richmond
stuff
is
to
a
do.
cool place.
Yeah, no, I'm a huge fan.
Very cool place.
So I'm blessed to be here, wife, two young kids, and I don't see myself going anywhere else. So very lucky to be here and to do this type of work.
And Sharif, for people who want to get in touch with you, what's the best way for them to do that?
Sure. So my cell is 804-566-0486. And I'm sure if you type in Sharif Gray on Google, you'll get a million things, to include our firm website, which is graybroughton.com. And then I also have a podcast, which we had Kenny on not long ago, called RVA Trial Lawyers, that me and a good friend run. So reach out if I can be of any help. I'm a big believer in telling those who want to become trial lawyers, like go get some criminal law experience, unless you're able to find like the gold job at like a firm where the lawyer really cares about your development and is going to get you into court. Because oftentimes in the civil practice, you're just not in court enough, in my opinion, to really kind of develop your sea legs. So that's why I tell people like go be a public defender, go be a state prosecutor, do that for a few years. Yeah, you won't make a ton of money, but you're going to learn so much. You're going to be exposed to so many different things, and you'll be able to transition very well to civil trial work. Should you want to do that, right? I mean, criminal work in and of itself can be very, very meaningful work.
Yeah, man, great job. Congrats on the successes. Look forward to what's coming down the pike for you. And thank you so much for being our guest today. Ladies and gentlemen, this has been Richmond, Virginia trial lawyer Sharif Gray. You've been listening to Best Practices with Kenny Berger, and we look forward to doing it again soon. Take care.